So much to cover here from my friends on the other side of the aisle. First, I want to just address something that my colleague from Wisconsin said when he said that the Constitution lays out very clearly in Article 1 the powers of Congress. And I would just ask him or any of my colleagues on the other side, if you could point me to where in the Constitution it confers subpoena power on Congress. You won't be able to because it is something established by the Supreme Court that is derivative from Congress's power to legislate. So the Supreme Court has set forth exactly what a congressional subpoena is authorized to do. In a recent case, you may remember it, the Trump versus Mazars case, because Donald Trump sued his accountant to prevent them from providing documents to Congress with a subpoena. Oh, congressional authority. That's what we're worried about here. Well, the Supreme Court reiterated purpose in order for a congressional subpoena to be valid. So I asked in our when we debated this, what is the legitimate legislative purpose that any one of my colleagues on the other side of the can identify to justify a contempt finding here where they have the substance recording included in the transcript, and everything else requested in that subpoena was provided to them. Yes, they're insisting on getting the audio of that transcript that they have. Now, not surprisingly, in the Oversight Committee, which has no jurisdiction over this anyway, they offered nothing. But I did hear in the Judiciary Committee, my friend from North Carolina who is here, refer in a subsequent hearing to demeanor evidence as a legitimate purpose for this subpoena. Now, demeanor evidence is like a sophisticated legal speak that is very esoteric and only for trial lawyers, but really it is completely irrelevant to Congress's legislative role because we don't try cases. There's no trial here. There's no demeanor evidence. As much as you may want to prosecute Joe Biden, there is no congressional prosecution of Joe Biden, and his demeanor evidence is no legitimate basis for this subpoena. Now, you of course know, and I don't even think you'd argue, that there's a legitimate legislative purpose to use the audio recordings in a political ad to support your dear leader, Mr. Trump. So that clearly falls outside of the range. Of course, my friends on the other side of the aisle should refocus from demeanor evidence to basic concepts like due process or executive privilege. Because the President of the United States asserted executive privilege over this audio tape. You may not like it, you may not agree with it, but you have no authority to determine that that is not a correct assertion of the executive privilege. And you know who else doesn't have authority to determine that? The Attorney General, who you are trying to hold in contempt. Due process. You're going to fine someone $10,000 without notice or an opportunity to be heard? You're going to say, we're going to fine you because, and you have no opportunity to make a defense, and there is no neutral adjudicator? You can go to court all you want, and that's where you went, and that's where you belong. And that's why this resolution is such bogus. But I have a warning for you, my friends. You will reap what you sow. In June of 2019, then President Donald Trump said he would, quote, defy all congressional subpoenas. And that is exactly what he did. During the first impeachment investigation, every single executive branch agency defied a lawful subpoena from Congress.
Gentleman's time has expired. Members are reminded to address their remarks to the chair.
I yield the gentleman an additional 1 minute.
Gentleman's recognized.
The State Department was subpoenaed, the Defense Department, not a single document. So I look forward to whoever one day is the Republican Secretary of State or Secretary of Defense to be held in contempt and fined, inherent contempt and fined $10,000. There were more than a dozen witnesses who refused to comply with the subpoena. And I'm not even talking about the 5 House Republicans who defied subpoenas in the last Congress that were determined by a court to be lawful and who would also be subject to inherent contempt because, of course, if this case where the audio tape is not provided, then blowing off a subpoena is definitely contempt. So you ought to be careful about the precedent you're setting because it is going to hurt you and your dear leader far more than us. I yield back.
Gentleman yield.